in the beginning.
Yes.
Then in
of course, Ms. Bensouda herself has alluded to more conversations of conflict that we will have in the course of our testimony today.
Yes, in that case, I think I will administer these two questions.
Very.
Chair, with your permission. Yeah. Counsel, perhaps maybe you can give back Ms. Bensouda SBT3, that was the High Court suit. I would need to make some references to it in administering my question. Is the document still with her?
I believe so.
Ms. Bensouda, do you still have SBT3?
Although it's not
We have it.
marked as S.
No, it's in the sounds, it's already there. Or perhaps, Secretariat, you can take summons to produce and then you hand over SBT3 to Ms. Bensouda. This one is. Yes, Ms. Bensouda, I will direct you to the second page of this summons and then refer you to number 7 and 8. If you can kindly read number 7 for us on the second page.
So that would be MOJ 5A. The same, it's the same. So.
Okay. MOJ 5.
5A. It should be in that bundle, but I would ask the Secretariat to assist. 5A. MOJ 5A.
Yeah, but is she not handled with SBT3 already? Yeah, so that's okay. They're all the same. So.
That's the one. MOJ 5. So we'll wait whether it has what he's asking for. No, MOJ 5 is the order. I think the reference is being used to page 2.
Page 2.7 and 0.8.
Page 2.7 and 0.8.
Yes, if you can kindly read both of them together.
Okay, MOJ 5A is a High Court order in suit number HC 168 between the Attorney General and Alhaji Yahya AJJ Janneh, and an order was made by the courts, and my attention is being drawn to paragraph 7 and 8 of that order. Okay, paragraph 7 says that the respondent B and an interim injunction is hereby granted, restraining him, his servants, agents, associates, and family members, or otherwise, howsoever, from disposing of or dealing with all the companies owned by or under the control of the respondent, his servants, agents, associates, and family members, or otherwise, howsoever, pending the conclusion of the investigation initiated by the Attorney General. That's paragraph 8 states that Augustus Prom, a firm of certified chartered accountants registered in the Gambia, be and are hereby appointed receiver, and consequently the custody and control be and is hereby granted to them of all the companies listed in the annexure mark 3 to this order for the proper administration thereof, pending the conclusion of the investigation initiated by the Attorney General. The order is dated 22nd May 2017.
Thank you very much, Ms. Bensouda. Now, let's refer to SSC 1. which is dated 7th of June 2017.
Okay. Yes.
My question would be, is there, that should be A on that should be A on SSC1? Is that the only one?
As far as I can see, unless you draw my attention.
Okay, we'll get to that. But now the point I want to make is, the High Court order was effected on the 22nd of May,
Yes.
2017.
Yes.
And at that point, the former president and his associates and family members were restrained, and the Attorney General was asked to take custody of this communist, and a receiver was appointed. 2 weeks after the High Court order, or let me say, from the 22nd of May, fast forward to 7th July, which is SSC1, you had a contract with Social Security, which was your engagement letter. So as at this point, it was no longer KGI, because the custody, the oversight, the management and operation of this communist already have been deposited in the care of the receiver. And in this case, the receiver was Augustus Plum. So my question is, during your appointment, because subsequently you'll be appointed on the 12th of July, 2017. Did it occur to you that KGI who Social Security have claims over with regards to some outstanding balances was no longer a corporate organization under the care of the former president, but was a corporate entity under the care of a receiver whose interest aligns with yours?
Whose interest?
Aligns with yours.
The receiver?
Augustus Plum.
Interest aligns with?
With yours.
Mine?
Yes.
I don't understand. KGI's interest can never align with my interest.
It's no longer KGI. As of the 22nd of May, it ceased to be KGI.
No,
there was a High Court order. Or I would ask you, in the abundance of your wisdom, can you interpret paragraph 8 for us, paragraph 7 and 8 for us? What do you understand?
By paragraph 7, the respondent, that was the former president, AJJ Janneh, was being barred from dealing with any of his companies, including KGI.
Good.
By paragraph 8.
And then when he was barred, who was given the responsibility?
By paragraph 8.
7, I'm still on 7.
No, paragraph 7 is just barring him. There was an injunction against him, his servants, his agents, his family members from disposing of any of his assets or companies or owned by or under his control. So 7 is just the barring, the injunction.
Pending
you cannot deal with any of these assets pending the conclusion of an investigation to be initiated by the Attorney General.
And that's the portion I'm after.
That is one. That was about the Attorney General had said he was going to conduct, he was in the process of an investigation on the Money Laundering Act. And it was on that basis that the court granted an injunction restraining the former president from dealing with any of his assets or any of his companies. That's 7. Paragraph 8, the court took control from him, control over those assets from him, and gave it to the receiver. The receiver becomes the caretaker of those companies. Those companies don't cease to exist. They continue to exist, but they cannot be operated by Janneh. Now, the receiver is appointed as the caretaker. That's what paragraph 8 means. He would take charge. He would act as if he was Janneh on behalf of the court. So the receiver's interest,
Ms. Bensouda,
yes,
he will act as if he was Yaya Jammeh.
yes,
Does it mean that he's answerable to Yaya Jammeh?
he's answerable to the court.
He's answerable to the
Yeah,
court.
because control is taken. The receivership means control is taken from him
And
and given to an independent person who reports to the court.
And whose interest was the court serving?
No one's interest. The court was serving the interest of justice.
The interest of justice.
Yes, because this case was initiated by the Attorney General. When you initiate a case, you have allegations. And the allegations have to be tried. They have to be investigated by the court through processes and tried. But in a case like this, where so many assets are involved, if you are the plaintiff and you bring a case against a person who has so many assets in respect of those assets, and you don't want that person to tamper with those assets while the case is on, you apply to the court to appoint a receiver to take charge of those assets pending the investigations. The court is neutral. The court is waiting for you now to prove your case against the person you brought to court. But meanwhile, it is, if you convince the court that if you allow the person, like in this case, Jammeh, to continue to be in charge of those assets, he may deal with them in a way that will defeat your investigation. And that is why the court said, okay, fine, I am persuaded that Attorney General, you have a good case against former President Jammeh, and I agree with you that if we leave him in charge of these properties and these companies whilst your case is going on, he may tamper with them. So I agree we should appoint a receiver as an independent. The receiver is always independent. As an independent caretaker of all these companies, and he will only report to the court. But meanwhile, Yaya Jammeh can only access a limited amount of money, which has to be from the receiver. So the receiver does not represent anyone's interest. The receiver is independent. He
Can you repeat
represents.
Can you repeat that? You said Yaya Jammeh would receive?
Yeah, the orders, it's in the orders.
Yaya Jammeh would receive what?
A limited amount of money from those companies. I think yes. If you look at paragraph 10, you see that, so many companies and accounts were seized. And paragraph 10 says that pursuant to section 51(6)(a) of the Act, it is ordered that provision for reasonable living expenses of the respondent, that's Yaya Jammeh, including his dependents, be paid out of the monies now outstanding to his credit in his personal account held at Trust Bank Limited. And the number is given, pending the investigation initiated by the Attorney General. Such amount not to exceed 200,000 per month. So the companies and assets remain the property of Yaya Jammeh until you prove a case against him. So the receiver is independent, he takes care of them for the benefit of the owner of the company until the case is decided. But the owner is prevented from having anything to do with the assets. So the receiver is an independent person, doesn't represent anybody's interests, reports to the court until the case is over. That's what it means.
Ms. Bensouda, we reconcile everything that you've said. And you would agree with me that the High Court's judgment was in respect of a case that was filed by the Attorney General.
There is no High Court judgment.
In the High Court of the Gambia, there was a suit.
Yes, but it never concluded.
Yes, but the Attorney General was the one who brought it up.
Yes, he
Is
brought
that
it.
correct?
He brought it, yes.
He brought it up, which means he have an interest in it. Which means he believes.
I don't understand your question.
I haven't asked a question yet.
Okay.
We are still reconciling what you said.
All right.
We are just trying to reconcile what you said, which means the Attorney General had an interest in those companies because the belief was public funds were used in the operations of what? Those companies. And he wanted to do an investigation. That was why the High Court in its judgment appointed a receiver. So the companies now, ideally, we are not talking about KGI. Because if you read the report of the receiver, that's Augustus Prom, he clearly indicates that in his oversight functions, he put managers in all of these companies.
He put?
Managers in all of these companies, so that he can have oversight over what their operations. So now what I am drawing at now is, as at the time of your appointment or your engagement with Social Security, the issue was no longer about Yahya Jammeh. There was already a High Court order. And that suit was initiated by the Attorney General, who appointed you on the 12th of July. And there is a particular case there. Although you highlighted one, I would have another one there to make it two, but there is a particular case there that involves KGI. And the claims that KGI were making was what? Against the receiver. Because the receiver was the one, in effect, who was supposed to pay for those claims. So now, would it be right to say that your interest in pursuing the loans that were given by Social Security are at opposite with the interests of the receiver?
Yes. Because the receiver is the receiver for the companies. Social Security was saying this, those companies owed them money. And that is why I was able to represent Social Security against the receiver as the receiver of those companies.
Yes.
And therefore there is no conflict. That's precisely the reason why I was appointed to sue those companies. And since the receiver was now in charge, was the caretaker, once you put the company, a company is put on the receivership. You cannot sue the company, you sue the receiver, because the receiver is the caretaker. So suing the receiver is like suing the company, it's like suing Yahya Jammeh. Yes, so we were on opposite ends.
Ms. Bensouda,
Yeah.
it will be convenient to say suing the receiver would be like suing KGI and suing Yahya Jammeh. Yahya Jammeh was no longer there.
It's not convenient.
No,
I'm talking law.
Allow me. Let me
Sorry,
complete.
it's not convenient.
Let me complete.
I'm talking law.
Ms.
Not
Bensouda,
convenient.
when you are, I always allow you.
Yes.
In fact, sometimes
Please
I give you
proceed.
2-3 minutes. You know,
Proceed.
I give you that courtesy to respond. So when I'm responding, allow me to come. And I will repeat, it will be convenient to say suing the receiver is like suing Yahya Jammeh or suing KGI. Yahya Jammeh is no more. We are talking about July, June of 2017. If Yahya Jammeh was here, the suit by the Attorney General would not be entertained by the courts. It wouldn't be. So, and if you look at SS1, look at B again, the 6.4 million. That 6.4 million also, you represented Social Security against the receiver. Is that correct?
Sorry, what's the question?
I'm saying, look at SSC1, 1B. You know, you highlighted 1A, KGI. I'm bringing 1B also to your notice, the 6.4
SSC
million.
1B.
Yes.
Yes, SSC 1B. I'm not sure I have it, but yes, go ahead.
Did you represent Social Security in the recovery of around $6.4 million is
Yes.
paid to Mr. Amadou Samba under the direction of the Office of the President?
Yes.
And this was also against the receiver, Augustus Prom?
Yes. That was perfectly in order.
So, is it, I just want you to enlighten us. How does Augustus Prom's rule as a receiver differs from the interests of Social Security that you were serving?
Augustus Prom was appointed by the court as an independent professional to take care of the assets. He reports to the court, but as the receiver, he's standing in the stead of the owners of the company. The owners of the company, just to put it in ordinary language, the owners of the company were Yahya Jammeh. That never changed in any way. The fact that you take the court takes the assets of a defendant, that was Yahya Jammeh, and gives it to a caretaker, doesn't change the fact that Yahya Jammeh continued to own those assets. The court is only preventing him from access, from dealing with the companies until the case against him is proven. So if you have any suit under the law.
Sorry to interject.
Sorry, let me finish my sentence.
No,
otherwise, you will not get.
I think I get the gist of it. Let me just ask this, Ms. Bensouda.
Sorry, let me finish the first answer, please.
Okay.
When this court deprives a defendant from access to their assets, it's temporary until the case is proven. When the case is proven, then the court gives judgment. And if that judgment favors the plaintiff that brought the case, those assets may be affected and the court will make orders concerning those assets. If the plaintiff, the judgment does not favor the plaintiff, those assets are returned to the owner. But meanwhile, under the law, under the Companies Act, if you want to take the company to court, when it is under receivership, when it's under receivership,
allow me.
The only person you can sue, you ask me the relationship, you can only sue the caretaker, the receiver. You cannot sue the company. That is why when Social Security instructed us, we had to sue the receiver. The receiver was the temporary caretaker of the company, KGI. KGI's interest was in the opposite direction at all times with Social Security interest. KGI is a private company, registered as a private company. Its shareholders are listed as Yahya Jammeh and his family. So there's a private company.
Understood. Now yes. Permit me to ask the question. The main reason I'm sticking to this point is, before the High Court suit, Social Security did not make any indications of initiating the recovery of these loans. If Yahya Jammeh was still in power, they would not have initiated anything with regards to the recovery of those loans. A High Court order was passed on the 22nd of what? May. Subsequently, on the 7th of June, you were appointed. On the 7th of June, 2017.
Yes.
You signed an engagement letter, or you sent an engagement letter to Social Security
yes.
to represent them.
Yes.
Fast forward to the 12th of July,
yes.
you became lead counsel.
Yes.
So now let's put all of this together.
Yes.
If Yahya Jammeh was here, KGI would be here. Social Security would never initiate recovery of those funds. And the High Court suit, the judgment was clear. The assets now are in the custody of a receiver. Yes, I appreciate the fact that you said the receiver is an independent person and he reports to the court. That's true. But the court is part of the government. It's part of the government. It's part of the state.
Court is not part of the government. There's a
separation. Allow me to learn. You see, yesterday you said something, Ms. Bensouda, and with due respect, you violate it. You said we ask the questions and you answer. Yes. But at your convenience, where you believe is convenient for you, you interject. And we don't do that to you.
Sorry, Mr. Chairman.
No,
let me appeal. I'm appealing to the chairman. There's a difference between a question and making a long statement. Now, if you make a long statement, the premise of which I don't agree with, and then you ask a question, the record will show that you made a series of statements, and then you followed it up with a question. Now, of course, this is not a court. In a court, you will not be allowed to do that. The court will say, ask one question at the time. You cannot make a statement and then ask a question. you have to ask one question at a time. And that's why when you make a statement I don't agree with, I tend to interject. I mean, no disrespect, but because when you subsequently ask the question, it may not be related to the statement you have made. And that's why I'm trying to correct the premise of your question. And perhaps that may determine whether what you ask. So that's why I'm interjecting to say that the premise on which you are building your question, these premises I don't agree with, because legally they are not correct with due respect to you, because the courts are not part of the government.
Am I permitted to
The courts are independent. That's why, Mr. Chairman, I would appreciate it if questions are asked, and I answer. But if they are preceded by long statements, that makes it difficult for me to answer the question. And I'm here to answer the question as fully as I can. That will be helpful.
Thank you. Thank you.
Can I proceed? Ms. Bensouda, in your submissions, do you know how many things you've said that I don't agree with? But I give you due respect and listen. You said a lot that I personally would not agree with. But I listen to you. Even though the preamble you will be setting will not correlate with the answer you give. But allow me. But I give you the courtesy. And again, I will repeat. The committee respects all witnesses and will treat you fairly. But you do not in any way, direct the way we'll ask questions. You don't.
And I
would lay foundations to enhance the basis of my question as much as possible.
Very well.
And I will repeat, I would never interject, even if you, in the submission of your answers, make statements I do not agree with. That is out of respect.
Very well. I apologize.
Honorable Chair,
I apologize for
demand
interjecting. So let's go.
She accords me the same. That when I'm laying my foundations, she have the right to disagree. But I'm requesting through you that even though she disagrees with what I'm saying, she gives me the respect and courtesy and listen to what I'm saying.
That's correct.
In her response, she can highlight her disagreements.
That's correct. Let's allow questions to flow.
Yes. Then I would say it again, Ms. Bensouda. A High Court judgment. The suit was on the 22nd of May. You were subsequently appointed by Social Security to represent them in the recovery of those sums on the 7th of June. And eventually, you got appointed as lead counsel on the 12th of July. And you did say that your interest in representing Social Security differs with that of the receiver. I agree. But what I'm telling you here is, or the point I'm trying to pass across is, you said the receiver is answerable to the court. And I said, and I insist, that the courts are part of the government. Because the courts are part of the legislature. And the government have three arms. If the receiver, at the end of the day, is answerable to the courts, and you are appointed as the lead counsel, how does your interest differ with that of the government? How does your interest in representing Social Security in the recovery of those funds differs with that of the government?
Sorry, I may answer now. Okay, thank you. As I have said, my interests, or my Social Security's interest, does not differ from the interests of government. Social Security's interests align with the interests of government. And that's why I am able to represent Social Security and able to represent the government simultaneously. So their interests align. Having said that, I must, with due respect, correct what you have said. The government is not, these courts are not part of government, neither are they part of the legislature. There are three arms of the state, and one is the government, one is the judiciary, and one is the legislature. All three are separate. But going back to the question, the interest of Social Security and the interest of government allies, that's why I was able to sue the receiver, and I was able to sue Yahya Jammeh. I was able to investigate Yahya Jammeh because the interest of government aligns with the interest of social support.
Who pays the emoluments of the courts?
The state.
The state pays it.
Yes, they're an organ of state, just like the legislature is an organ of state.
Who
just like the
pays
government.
the emoluments of the parliament?
The state.
Who pays the emoluments of the executive?
The state.
So how do you differentiate and place the courts as a standalone, as if whatever is under their care is not for the common good of the people?
There are certain fundamental principles of the Constitution that we all take for granted when we are lawyers and members of, perhaps the public may not, but there are three arms of government. The state means there are three arms of state, sorry. The government, which is the executive, that's the president, led by the president, that's the government. And then you have the courts, and then you have the legislature. These arms are independent, and they act as a check against each other. And that is why that's why you have this committee, because the legislature now is exercising its power to check what the executive did in appointing a Janneh commission. So the three of them, certainly they all form together part of the state, but they act as, that's what is called check and balances. All of them act independently and make sure in having an oversight over what each other arm is doing, it ensures that check and balance ensures that each of the arms are acting properly. But the judiciary is independent, and they value that independence. The Constitution reinforces that independence. The judiciary acts as a check on the executive. The National Assembly acts as a check on the executive as well. But the judiciary is independent. The National Assembly cannot act as a check over the judiciary.
Ms. Bensouda, right now I'm not interjecting because you are not answering the question I asked. We appreciate those responses, but those are facts that we know. The point we are getting at is, you see, the receiver is answerable to the courts.
Yes.
So now, where we want clarity is, how do you treat the courts as a standalone? And you separate them from the interests of the nation. Because if you understand my line of questioning, what I am trying to put across here is, the receiver, though answerable to the court, was serving the greater good of society. I appreciate your responses that the courts and the government are different. That's okay. We'll take that. Okay? But how do you treat the courts as a standalone? In such a way that whatever role they are playing cannot be attributed to that greater system called governance.
Sorry, you want me to respond to that? It's not I who am holding, putting...
Ms. Bensouda, I'm asking questions. You are on the book. I'm done.
Yes,
That's why you don't get
I'm
it.
looking at the Constitution.
Yes.
Yes, I'm answering your question. I'm going to answer your question, but I'm going to look, I'm looking at the Constitution so that I can assist as well. It's not I who am saying the judiciary is standalone. It's the Constitution that says the judiciary.
We are not disputing that. No, allow me. No. For the records, what you are saying, no one is
you
questioning.
You're interjecting now. We promise
yes,
we will not
interject. It's my responsibility to guide as well. I'm asking the questions.
Yes,
that
but
one, that one
well,
have
let me answer
nothing.
my question.
No, allow me. That one have, because what you are putting across is not what I said. No one questioned the independence of the judiciary. No one questioned.
Okay, thank you very well.
No, wait.
Thank you.
Okay, if that is what you were submitting, we shouldn't have got here. I told you there are three arms of the state: the judiciary, the legislature, and the executive. And your submission was the courts are a standalone. And that's the argument we are on right now. And that's where I want you to enlighten us. How do we treat the courts as a standalone to such a level that the interest of the receiver, Augustus Prom, stands at opposite directions with your interests? Because you said you have the same interest with the government, but your classifications of the courts is putting them on a standalone.
Yes.
Yes, so that is the explanation we want. Then we'll appreciate it.
The courts are independent, and that means they stand alone from everyone else, including the executive and the legislature. And this is in Section 123 of the Constitution. In the exercise of their functions, they are independent and only answerable, independent and subject only to the Constitution and the law, except as provided in this chapter, and shall not be subject to the control or direction of any other person or authority. That makes them independent and stand alone. They serve nobody's interests. They serve the interests of the law. Now, the receiver appointed as the receiver of KGI is appointed by the court to be an independent arbiter, an independent caretaker. He serves, if there is an interest he serves, it's the interest that is closest to what he's doing is the interest of KGI. He was appointed as receiver. He steps into the shoes of the managers of KGI, takes management, in other words, management is taken from those who are managing KGI on behalf of the president and control of the president and given to the receiver temporarily. He runs those companies, but if he makes profit, the profit goes back to KGI. And at the end of the case, if the Attorney General does not prove his case, all the companies are returned to AJJ Janneh with all money made by the receiver. So the receiver's interest is not the same as the interest of the state. The receiver is a caretaker, is an independent person who has been appointed to take care of the company while the case was going on. So if that company owed money before the receiver was appointed, you sue the receiver because he's the caretaker now. You cannot sue Yaya Jammeh, you sue the receiver. That's how it works. That's the law. You may have an opinion, of course, about it, but for me, I can only tell you what is in the law. And that is why when Social Security approached my firm and said they were owed money, and that we should sue, and the receiver had already been appointed for KGI, we brought the action against the receiver. And first, because the receiver had been appointed by the court, we had to file a motion to seek the permission of the court. Because when there is a receiver, you cannot just directly sue. You have to seek the permission of the court to sue the company that is in receivership. And that's why the receiver was sued. So nothing changes in the receiver's interest does not align. The receiver's interest is independent, but insofar as they were receivers for KGI, their interest was in direct opposition to the interest of Social Security, whom they owed money. And the court has no interest. The court is independent. It makes an independent judgment. It doesn't favor anyone. The court is expected to make an independent judgment. It's neither there for the state, and that's why we have a State Proceedings Act. We have an act that is called the State Proceedings Act.
Can I interject now?
If I may just explain that small thing.
No, allow. You've answered the question. So allow me to come now.
Well.
Okay? Your response on the section of the Constitution you quoted, 120,
Yes.
subsection 3.
Yes.
And I will read. It says, in the exercise of their judicial functions, the courts, the judges, and other holders of judicial office shall be independent and shall be subject only to this Constitution and the law, and except as provided in this chapter.
Shall not be subject. Yes.
Okay, shall not be.
Subject to the control or direction of any other person or authority. Including government. Especially government.
Can I complete?
Especially government.
Can I complete? Can I complete? We do not have the competence to interpret the Constitution, but the independence of the courts is with regards to their operations. At this instance, our understanding is the court have issued a judgment. A judgment have been passed.
In the courts? I'm not aware of it though.
Check.
An order, Honorable Member.
On the 22nd of July, 2017, of May rather,
An order.
That was an order. It is already done.
It's not a judgment.
Okay.
There's a difference between a judgment and a
Let me learn. Allow me to learn.
Okay.
Okay. Okay. The court have passed an order already, and the receiver is the one who is responsible to execute that order. So it is not the court's occupation anymore. The stewardship responsibility have been given to Augustus Prom. And the question here is, whose interest was Augustus Prom serving?
Augustus
Allow me.
Oh, okay. I thought
allow me
that
to
was
come.
the question.
Okay.
All right.
And that have been the question ever since. The courts, in their independence, what they propagate is for the common good of society. Be it their judgments, be it their orders. So it is no longer about the independence of the courts. We are not talking about that. What we are talking about is an authority, an entity. A receiver have been what? Appointed to take care of those companies. And no matter how you classify the courts as a standalone, they are part and parcel of this country. So if at all the receiver was serving the interests of the court, we agree. Let's agree that the receiver was serving the interests of the courts. But the courts at the end of the day are serving the interests of the state. So how does your interests differ with that interest of the state to a way that you will represent a company that will have claims over the receiver? And that will be my last question. I'm not talking about the independence of the courts. We know that. I'm not talking about the independence of the judiciary or the executive.
Okay.
We are talking about the interest that the courts were serving. And how does that differ with the interest of your entity in representing social security?
Well, I don't know. I don't know. I'm not entirely sure I understand your question, but let me say this. We represented Social Security, which is a public entity. Social Security's interest aligns with government. We sued the receiver because the receiver was the person in control of KGI.
Who was acting on the instance of the court?
Was representing KGI as caretaker.
No, acting on the instance of the courts. KGI is no longer there.
No, he was appointed as receiver of KGI. KGI
Yes.
was always there. He is receiver of KGI Company Limited. That's his title, receiver of KGI. Meaning the person in charge of KGI.
There is already an order.
Yes, that's what the order said.
Yes, I know.
That's paragraph 8, that Augustus Prom, a firm of certified chartered accountants registered in the Gambia, be and are hereby appointed receiver and consequently the custody and control be and is hereby granted to them of all the companies listed. So by virtue of that paragraph, he became receiver of KGI International. KGI International owed Social Security claim. KGI International owed Social Security money. Social Security appointed us to claim against KGI. Since KGI was in receivership, we could only sue the receiver of KGI. You cannot sue KGI. You can only sue the receiver of KGI.
So it was normal to represent KGI. So it was normal to represent Social Security.
Very normal.
Even though the receiver,
very normal,
who was supposed to pay the claims,
yes,
was acting on the instance of the courts, while you were appointed as lead counsel?
Yes, very normal.
Thank you, Chair. That's all I want.
Very normal.
Yes.
That's fine. Thank you so much. That was a good exchange. The council, can we proceed?
I'm not sure if the Honorable Chair wants to take a break or the witness wants to take a break. If not,
no, I don't want to take a break.
I can
It's
proceed.
late enough. Thank you.
Honorable Chair.
Yeah, council, it appears that we have a few more questions on the high table, from the high table. We can allow them to ask. I think it's related to exactly what the honorable member was asking as well. So, Ms. Bensouda, we have a few more questions for you.
Thank you.
Honorable Sir, please go
I'll
ahead.
answer to the best of my ability.
Counsel, please proceed.
But I did promise that I would move on from this issue, but from the exchange, I'm obliged to just ask one more question.
But Counsel, if it is in the interest of the committee, of course, we can take a break for this 20 minutes and come back at least.
The committee can advise me if it's in the
20
interest.
minutes.
I think that's important.
But can we have a discussion on how long the session would be so that we are courteous to the witness as well?
That depends on what you have on the table, what you have for the witness,
I have
and
several issues.
So Ms. Bensouda will have to be with us till 10 o'clock.
Is that okay, yeah? I think you should call him to come. You should. Ten is a bit late, but I don't have a problem because I really would like to be able to make progress and hopefully finish my testimony as sooner rather than later. That's fine, but perhaps 20 minutes break is too long. If we are going to go until 10. Is it Maghrib? Is it for Maghrib? Okay.
Close to Maghrib, that's why. Unless we can pray.
Perhaps we can conclude this topic if it's possible before we move on and then break.
Yes, perhaps I could just ask this question and then we go for the break.
Okay, then by 7 o'clock, 6:45 we should go on a break. Maghrib will be around 7 o'clock.
But Honorable Chair, I would want to appeal that 10 might be a bit late. If we could, as you please.
Let's take a break after your question and then we will determine that later.
Okay.
Please proceed.
As you please. All right. From the engagements you had with the honorable member, Ms. Bensouda, I would like to make a few things clear and then ask a question. That indeed, from the exchange, I could tell that perhaps there was a misunderstanding. But I would also like to state unequivocally that the members do understand the principle of separation of powers, as you were trying to allude to, and they do understand that the judiciary is independent and that the government does not control the judiciary. I believe what the question was about was that because the receiver manager stepped into the stead of the directors in companies that the former president had an interest in, and your clients had an opposing interest to those companies, there was perhaps a conflict there, because then the interests of your clients and the interests of the government are adverse. If I could put that to you, what would be your reaction?
Those companies, no, that is not correct. Those companies did not belong to government. They belong to Yahya Jammeh. So the receiver stood in the stead of Yahya Jammeh temporarily. They never ceased to be companies of Yahya Jammeh.
Okay, I think
so I was representing.
You misunderstood my question.
All right.
I never said that the government owns those companies. I said because the receiver stepped into the stead of the directors of the company, and assumably the interest of Yahya Jammeh is to have those companies to be a going concern. And the interest of the receiver and the government is to have those companies be a going concern. And of course, as you alluded to, at the end of the case, if at all an adverse finding is made or judgment is made against the former president, then the receiver would have to pay monies or sums to the judgment creditor. Now the question is, because your interest was adverse to that of the receiver, that of the companies that the receiver was acting in the stead of, that a conflict, that your interest and the government's did not align. That is the interest of your clients.
That is what I don't understand, because it is primarily because the interest of Social Security and the interest of the KGI, under KGI, whether under the control of the directors appointed by Janneh or under the control of the receiver, their interest and the interest of Social Security don't align. Government doesn't come into it until judgment is determined and found in favor of government. So government interest does not arise at all when it came to the receivership. The receivership was a caretaker of those companies. If anything, he was representing the interests of the company and indirectly the interests of the owners of the company, which is Yahya Jammeh. Government doesn't come into it at all. So even if judgment is given in the case in favor of the Attorney General, the court judge would have to determine whether that judgment would affect KGI or not. It's not automatic. So the interest is not this. Government doesn't come into it. That's my answer.
Okay. If that would be your answer, then I'm tempted. Honorable Chair, it's 6:45. You had one that I stopped, but I have a follow-up question. Because I'm tempted to disagree with you and now see the wisdom of the question of the honorable member. Because government does have an interest, whether indirect or direct, because it was government that recommended the appointment of the receiver to the court. And that is precisely to ensure that those companies are a going concern. It is that receiver that you took to court.
That is not interest that we look at when we look at conflict. When a plaintiff takes a defendant to court, of course they are interested in the sense that they want to win their case. So if the government sued Yahya Jammeh for monies, and some of the allegations are in fact that monies are owed to Social Security. That's one of the allegations, and that's why Social Security transactions with the president is being looked at. So government, Attorney General sued Yahya Jammeh, and the case is against him. The Attorney General said, look, I'm investigating Yahya Jammeh, but if we allow Yahya Jammeh to continue to control these companies, the companies might disappear, maybe dissipated and so on. So we want an interim order preventing Yahya Jammeh from accessing these companies, from operating them. And the law provides a mechanism for ensuring that the court, as an independent arbiter, is able to appoint an independent professional called the receiver to take charge of those companies to prevent the case of the government being rendered nugatory, as we say. Because you go to court and when you get the judgment, all the companies have disappeared, all the money is disappeared. Then what's the point in going to court? So Augustus Prom was there, not as the interest of government.
I don't mean to interject.
Not the interest of anyone.
I don't mean to interject,
yes.
But that's precisely what the honorable member was getting at. That the interest of government is that the companies are a going concern, at least until the end of the suit or of the whole exercise.
They are not dissipated, yes.
That was, I believe, Honorable Member, you can correct me if I'm
not
wrong.
necessarily a going concern. Remember, if you look at the receiver's report, he said some of the companies were not operating.
Yes.
So the receivership was to ensure that they are not dissipated. Whatever property the companies own,
yes,
is not lost before the investigations were concluded. So government's interest is to make sure that when they get judgment eventually, there's something they can execute.
Exactly. I believe that was the point Honorable was trying to make. Please correct me if I'm wrong.
No, Counsel, government's interest is to ensure that those businesses remain viable. Because if they are not viable at the end of the day, even the claims Social Security is making against the receiver will not be paid. So for me, what I find hard to believe is, how do you separate the interests of the receiver, the interests of the courts, from the interests of government? I can never be convinced on that. I believe all the interests are the same, and it was one person fighting against him or herself. That's all.
Just for the record, the interest of the court is indeed the interest of justice, but I do get the point you're making that, Honorable Chair, I believe it's time. Well, perhaps the witness has not reacted. If we can allow her to react and then go on.
I'm not too sure. That was just a comment by the member.
Yes, but it's fair. It's only fair to allow her to react before we go to the.
Do you think she wants to
these are matters of law. It's not what I say. It's a matter of law, and the law is clear that the receiver is appointed by the court independent. Ultimately, government is interested in recovering its debts, including social security debts. Government was not only interested in recovering. It was acting on behalf of all public enterprises, all of them. And that's why the suit was formulated. It was not money Janneh took from government directly. The allegation was he took it from public enterprises. So government was acting on behalf of all the public enterprises and public entities. So their interest was the same, either to recover the money from KGI if they can, before the case is finished. That's what Social Security wanted to do. Or to recover at the end. Whatever it is, Attorney General was acting on behalf of all public entities that alleged that Janneh took money from them.
Thank you. Thank you, Ms. Bensouda. Counsel, I think it's a convenient time for us to take a short break, pray and come back, and we'll proceed from there. Thank you. Meeting adjourned.